Hey guys, and welcome to today's video. Today we have a sovereign citizen that I've covered before. It was the said who decided to walk out of his jury trial because the judge wouldn't play his stupid games. So, he won a stupid prize of having to serve 45 days in jail for contempt of court. Well, he's back. Except he's no longer facing petty traffic charges as he's upgraded to facing charges that can potentially land him in prison for the rest of his life. Here's a short news clip summing up his degeneracy.
A Grand Junction man was arrested in Florida by U.S. Marshals on an extradition warrant for Colorado. The U.S. Marshals Task Force and Walton County Sheriff's Office arrested Pablo Rocco Forenza this morning. The Grand Junction Police Department says the allegations stem from a possible intimate relationship with a victim that began when they were under the age of 15. Forenza is accused of sexual assault of a child, sexual exploitation of a child, and possession of exploitative material in Grand Junction. He's currently held in Walton County Jail, waiting extradition back to Colorado.
Now, we have several hearings to cover, starting with a short one that is a follow-up to his traffic charges that he walked out on. So, let's begin.
What do you have?
23T 125.
23T 125?
Yes. Pablo Forenza.
This is People versus Pablo Forenza, 23T 125. Mr. Forenza does not appear. His appearance is hereby waived. Mr. McCall?
Based upon the other legal issues that Mr. Forenza is facing, the people are going to dismiss this case.
The court hereby grants the motion to dismiss. I vacate the pretrial readiness conference set for tomorrow afternoon, May 6th. I vacate the jury trial, which is set on May 14th and 15th. Thank you very much, Mr. McCall. Let's go off record.
Yeah, you're mistaken. But I don't blame her for not knowing the full details. But he was in the courthouse with the jury present, and because the judge wouldn't play his soft-tardian games, he decided he was just going to walk out of that jury trial, earning him a direct criminal contempt of court.
You can come stand next to me.
All right, looks like Mr. Forenza is present. Mr. Forenza, did you watch that video that talks about your rights?
Yes, sir.
And did you understand your rights on the video?
Yes, sir.
Can you waive for the reading and advisement, Ms. Atkinson?
Yes, Your Honor.
All right, so let's talk about bond and the protection order. And so, Mr. Savage.
Thank you, Your Honor. We did attempt to make contact with the named victim, and we have not, as of now, heard back from her. I just wanted to make sure she's not on. I don't think she is.
I don't see she's on WebEx right now.
Yeah, so, as the court probably knows, I think these are obviously, generally speaking, very difficult types cases to, I'm sure, for the court to set bond on and for the people to make bond recommendations on, especially having not heard from the victim. But obviously, Your Honor, the allegations are extremely concerning in this. They're, as the court knows, according to the victim here, they started a sexual relationship back when the victim was allegedly 13 and the defendant was 21 years older than her. I realized that this spanned over different states and over several years, and some of the things allegedly that happened in Colorado were when she was a bit older. But regardless, Your Honor, the allegations certainly are extremely concerning. And I think what makes it difficult, at least for the people, to make bond recommendations on these types of things is it's hard for the people to recommend or know what sort of non-monetary conditions could even be in place. I mean, at this point, I don't have even really a good address to know exactly where the victim is. I assume the number that telephone number we have from her is okay, but we have not heard back. So I'm concerned to just ask for like a GPS type situation. I certainly will tell the court I'm asking for no contact with the named victim in this case. And I'm also asking for a provision specifically that the defendant be prohibited from having contact with anyone under the age of 18 years old. I'm also asking for pretrial services. And I think, Your Honor, just based on the allegations, the serious nature of them, the fact that these are the types of charges where if he were to be found guilty, obviously would carry, indeterminate type sentencing options. I certainly think that increases risk potentially for failing to appear, those sorts of things. I know he does have a couple prior failures to appear in the last 5 years, 3 of them to be exact. I am asking the court at this point in time, Your Honor, to set a high cash only bond. I would ask the court to set something in the neighborhood of $100,000 cash at this point in time, as I do not believe at this point in time the court can set non-monetary conditions that would assure the safety of this victim at this point in time. Thank you.
All right, thank you, Mr. Savage. The court should put on the record, just so both parties are aware, the court is somewhat aware of some of the factual circumstances in Mr. Forenza's pending other criminal matter here in Mesa County, including the fact that he fled his jury trial back in November of 2025. And so that is something that the court is aware of and thinking about in terms of what would be an appropriate bond in this particular case. So, Ms. Atkinson.
Your Honor, I believe Mr. Forenza had a question. May I please mute?
Yeah, absolutely. The court should also put on the record, I'm also aware he was extradited from Florida as well.
Okay.
Okay.
Yes, Judge. So we are requesting, I'm sorry, Judge. 1 second. So Judge, we are requesting that the court impose a $10,000 cash only bond or a $100,000 cash or surety. Mr. Forenza, I understand that the allegations in this case are extremely serious, but they are just allegations at this point. Mr. Forenza is presumed innocent of this. The court is required to presume that he's eligible for release with the least restrictive conditions. He's a CPAC Category 1 with extremely minimal criminal history. It sounds like the district attorney's office cannot even locate the alleged victim in the case. I think the court can consider how that might bode for trial at this point. My understanding was that he was apprehended in Florida because he was down there for work. He wasn't attempting to flee the jurisdiction at all. He lives in Mesa County currently. He works in IT. He's had that job his entire life, and he thinks he will still have that when he gets out of custody. It's contract work, essentially. He would be willing to comply with some non-monetary conditions. I disagree with the district attorney's office that we can't assure community safety with non-monetary conditions. We could provide for no contact with children under the age of 18. He would request a exception for his biological daughter, Forenza. Does not live with him, but he would at least want electronic communication with her. He does need to be out working. There's a lot for him to situate. If he's going to be fighting this case, he needs to be working on getting his belongings situated. He needs to sell his vehicle. He's looking at hiring legal counsel. He would really like to be out of custody to assist with the investigation in this case, for which we are going to do a lot of. He has a lot of family in Grand Junction. His stepmother and his 2 brothers are here. He's lived in this area a long time. This is a very cold case, and the allegations are very, very old. He's been out in the community since then. There aren't really any other pending allegations. I understand that there is an allegation that he failed to appear for a traffic trial. My understanding is that Mr. Forenza was under the impression, I don't know at this point whether or not it was mistaken or what was happening, but he was under the impression that he didn't need to appear for that date.
$250,000 bond. Well, I'm just going to say it. $250,000 isn't high enough now. He won't be able to pay it, and he's going to be showing up to all his future hearings in jail's issued clothing.
They are much less serious charges.
No.
It's a traffic case.
To be clear, he was there for his trial,
okay.
Said, I'm not doing this anymore, see you later, and left, getting past the deputies before they were able to apprehend him as he was leaving the courthouse. In the middle of the jury trial.
Thank you, Judge, for that clarification. But my understanding is that there was a belief that the trial didn't need to. There was a belief that he didn't need to be there, was my understanding.
Yeah, I would agree with that. The indication is that Mr. Forenza does not believe that the prosecution can prosecute him. He's asserting he's some sort of sovereign entity and can't be prosecuted.
My understanding of Mr. Frenza is asserting right now he's not a sovereign citizen. But there are non-monetary conditions, I believe, in this case that can allow him out in the community. The bond we are requesting is very high and would be further assurance that he would appear. I don't know what the bond situation was in the traffic case, but I doubt there was a monetary bond attached to it. I do believe with the addition of a monetary bond, we could ensure that Mr. Frenza appeared for court.
All right, thank you, Ms. Atkinson. The court has considered the arguments of both parties and would make the following observations and notations. First of all, I look at three factors: flight risk, danger to the community, danger to a specific person. In this particular case, the court has substantial flight risk concerns for Mr. Forenza. Obviously, Mr. Forenza, even in something as minor as a traffic charge, does not believe that he needs to show up to court, and quite frankly doesn't believe the court has any sort of jurisdiction over him or can make him do anything, to the degree that he simply walked out of his jury trial contrary to the orders of Judge Grattan. And so that inspires little or no confidence that Mr. Forenza is going to show up as directed. He was extradited here from Florida. Whether or not that's for work or for other purposes, it's another indication that Mr. Forenza has the means and ability to leave the jurisdiction. And in light of the fact that he's facing mandatory, possible lifetime prison sentences, in this particular case, there's a significant incentive on his part to flee. The court would note that the evidence in this particular case, the court isn't going to have the trial on the matter right now, but the court can consider the likely sentence pursuant to 16.4, 103, and 105. And there's substantial evidence, at least in the affidavit, that Mr. Forenza potentially committed these offenses. This would include his own statements in messages and emails that were sent to the victim in this particular case. And so while the court understands that the allegations are older, a lot of times in sexual assault on a child cases, the allegations are from older. There's nothing about this particular case that is stale by those standards. And so the court also has significant community safety concerns in light of the allegations. The allegations involve significant grooming behavior, a pattern of conduct. It's not some sort of isolated one-time incident, but something that went on for years. And again, involved some very concerning behavior, at least with what's alleged in this particular case. And so because the court feels that Mr. Forenza is a very substantial flight risk, and because the court feels that he is a danger to community safety, the court declines to do what the defense is requesting here in this particular case. The court thinks that a $250,000 cash-only bond is what is appropriate here in this particular case in light of those concerns. And so that is what I'm going to...
No, thank you for setting his bond so high that he may never see the light of day again, even before his trial and future conviction have been completed. Now, we're going to head to his bond reduction hearing.
I am going to make a requirement to that bond that Mr. Forenza report to pretrial services supervision, and another condition of the bond is that he not have contact with anyone under the age of 18. Now, Ms. Atkinson, I think you did mention that he has a biological daughter that's maybe under the age of 18. Is that correct?
That is my understanding, yes. Her name is Angelina Forenza.
Angelina Forenza?
Yes.
Okay, so the court will make an exception to that bond condition and allow him to have contact with Angelina Forenza. The court is going to issue a mandatory protection order that says that Mr. Forenza shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he's charged with committing. Further, he shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim would likely be found. Specifically, he is prohibited from going to Drive, Grand Junction, Colorado, 81504. Further, he can't have any sort of contact with Brittany Williamson. That would include direct or indirect contact or communication with her. The court will note that this, first of all, I have to advise you on what would happen if you were to violate the protection order, Mr. Forenza. If you were to violate the protection order, you could be subject to punishment for contempt of court, you could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged. This case is assigned to Judge Barrett's division. And so what we're going to do is come back for formal filing on April 22nd, which is a Wednesday at 8:15 a.m. Mr. Forenza, I can tell you that you're going to be allowed to readdress bond in front of Judge Barrett because he's your assigned judge on this particular case. Would you like us to appoint the Office of State Public Defender to represent you so they can be with you and assist at that next court date?
Yes. Yes,
Okay.
Your Honor.
We're going to appoint them right now, so they'll be with you and can help you at that next court date. But the next court date is April 22nd at 8:15 a.m.
So in other words, no bond reduction for him, and get used to being told when and where you're allowed to eat, __, and sleep. Now, he hasn't said too much softish nonsense up to this point, probably because he was represented by counsel, but all of that is about to change. And in the next hearing, he's going to fire his attorneys that he hired because he
Ms.
thinks he
Atkinson?
can do a better job himself.
Mr. Forenza, 26 CR 299. Mr. Forenza appears in person in custody with his lawyer, Ms. Atkinson. Good morning, ma'am.
Good morning.
Ms. Bauer, I believe. Yes, for the people. This is a formal filing.
We have received the complaint and information, and we would waive further reading and advisement. Mr. Forenza is entitled to a preliminary hearing. We are requesting a preliminary hearing, but we're not requesting to set it within the 35-day time frame. We would request to address bond, and we would request if the lawyers could approach for bond argument.
All right. Court has heard arguments from counsel up at the bench. I've considered the same as well as the file. The primary purpose of bond is to ensure that a defendant appears at each and every future court date. Other purposes of bond are to ensure compliance with conditions of bond as well as community safety and victim safety. When fixing bond, I consider a host of statutory factors, all of which the court has considered here, even though I may not mention them. I consider defendant's ties to the community, employment status, criminal history of failing to appear or appearing for court, and any empirically based scoring instrument that may assist the court in understanding a defendant's risk level should he or she be placed on bond. I consider the charges as well. Defendant is a CPAT category 1, indicating he's at a higher likelihood to succeed on bond. The court doesn't put a lot of stock in that because of the following reasons. The charges here are exceptionally aggravated and involve the possibility of the defendant remaining in the custody of the Department of Corrections for the rest of his life. The underlying allegations, too, are very troubling and concerning if true. They span some period of time, involve alleged messages that are of great concern to the court. The defendant has a history of failing to appear as well 3 times in the last 5 years. Of most concern to the court is that he was at a jury trial not too long ago, refused to answer the call of the court, and then ran out of the courtroom and had to be arrested at a later date and time, indicating to the court that he is at a extremely high risk to flee. That was a case involving a low-level traffic offense. So if he's willing to engage in that behavior for a traffic offense, it's highly likely that he would do so for something as significant as the allegations here. He has also, as the court can see, looking through the files, evinced some indication in other civil cases of, I don't know how to describe it, but concern that he would not follow the orders of the court. I'm looking at a couple of protection order cases, 25C 656 and 655. He also has a historical history of not complying with court orders, according to the CPAT twice, I'm sorry, not twice, but once in New York, a criminal attempt, second disobey a court order conviction from 1999. Considering all of the foregoing and less of a concern are those civil matters that I referred to, but still within the court's registry that I wanted to take a look at, and something that I mentioned, but not dispositive by any means. The court concludes that the bond set at $250,000 cash only while high is the least restrictive I can impose in order to ensure the purposes of bond are met, particularly community safety, but most importantly, victim safety. The defendant is a flight risk. He was extradited from Florida. He did not flee to go there because of these charges, I note, but nevertheless, that's where he resided at the time he was arrested. given the representations of the prosecution as well about ongoing investigation or investigations, the court finds that this is the least restrictive bond it could impose in both type and amount in order to ensure the purposes of bond are met. It remains as set.